The Law and You. A look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You. Presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 828, and it is coming to you on Monday the 13th of June, 2016. On this program, I will speak to you on the topic Private Members' Bills and Motions in Parliament. But before getting into the topic, a few preliminary comments first, and as usual, my condolences go out to all families which have suffered recent bereavements, and in particular, the family of that lady who was so tragically burnt in the vehicle. From the reports we received, 2 ladies and a child were burnt in the vehicle. One has died and the other one has been airlifted. Let us pray for the recovery of the one who has gone abroad for medical attention. Condolences to the family of the late Mother Jeffrey of Spring Village, who was laid to rest on the weekend. And special condolences to our brother teacher Lauren George and the rest of his family on the passing of his father. As I always say, who knows it, feels it. And to those who are indisposed, ill, in hospital, or home in bed, my best wishes to you for your full recovery. And on that note of death, those of us who listened to the tidings coming out of Orlando, Florida on Sunday morning would have been shocked, disgusted, and totally dismayed at the senseless killing of 50 persons and the wounding of another 53 at a nightclub in Orlando. My heart goes out to all the relatives of the victim and to the government and people of the United States of America. It was said to have been the largest number of persons killed by gunshot at one event in the history of the United States of America outside civil war. There have been calls for gun control, but I think the situation is far beyond that. The nation of the United States of America was built on the power of the gun, and unfortunately, the gun culture is part of American culture forever, in my humble opinion. Excuse me. Now, I was extremely pleased when I listened to the debate in Parliament a few days ago on the new bill, which is now an act of Parliament, which has done away with the old oath of allegiance to Her Majesty and has replaced it with an oath of allegiance to St. Vincent and the Grenadines. I listened to the bill being presented by the Honorable Camilo Gonsalves, and it was a beautiful presentation. Congratulations to the brother. As you know, those of us who went through the Constitution review process and who aimed at having the Constitution changed, one of the proposals we had put forward was for a change in the oath of allegiance, and now that it is done, I, for one, would like to congratulate the government side in Parliament, since unfortunately the opposition was not present at the sitting, but I'm sure if they were present, they would have supported that bill, so that persons could take an oath of allegiance to this country, with no disrespect, of course, to Her Gracious Majesty Queen Elizabeth II. All right, get into the topic for the evening: private members' bills and motions in Parliament. Who is a private member in Parliament? Well, let me give you a clue. All members of the opposition are private members, and a few on the government side are private members as well. A private member is a member of the House who is not a minister of government. Let me repeat. A private member of our House of Assembly, our Parliament, is a person who is not a minister of government. So for the purpose of authority, one can regard Parliament as being divided into three spheres of authority. Firstly, that of the leader of the House, who is normally the Prime Minister. Secondly, that of ministers. And thirdly, that of the rest. So all the rest of the members of Parliament, I do not include the Speaker and the Clerk. I'm sure you would understand that. All the rest are private members. And our Constitution has a clause, which was one of those clauses we tried to get rid of during the Constitution review exercise. That clause says basically, if you are a private member in the Parliament, you do not have the authority to put forward any bill or any motion, and motion is another name for resolution, that has financial implications. So you may feel, well, there is an opposition in Parliament and they are numerically very strong. That may be the case. But they have no authority to bring forward in Parliament for debate and vote any bill or any motion or resolution which has financial implications. Only ministers can do that. Or if the private member seeking to put forward a money measure has the support of a minister in that endeavor. For those of you who might have your constitutions with you, and I know quite a few of you do have your constitutions with you, and I congratulate you, you've been very astute students. I would invite you to turn to section 44 of the Constitution. And let us see what Section 44 says. It says, except on the recommendation of the Governor General signified by a minister, the House shall not A. Proceed upon any bill, including any amendment to a bill, that in the opinion of the person presiding makes provision for any of the following purposes. 1. For the imposition of taxation or the alteration of taxation otherwise than by reduction. 2. For the imposition of any charge upon the consolidated fund or any other public fund of St. Vincent, or the alteration of any such charge otherwise than by reduction. 3. For the payment, issue, or withdrawal from the consolidated fund or any other public fund of St. Vincent, of any monies not charged thereon, or any increase in the amount of such payment, issue, or withdrawal. Or 4, from the composition or remission of any debt due to the government. Or, and again we continue with the main clause, the House shall not proceed upon any motion, including any amendment to a motion, the effect of which, in the opinion of the person presiding, would be to make provision for any of those purposes. That was Section 44 of the Constitution. So you may think, well, you are electing people to Parliament, 15 elected, and then there will be 6 senators, plus the Attorney General. And you may feel, okay, they are all members. Well, in the case of the elected members, you will say, well, these are people elected to represent the people in the various constituencies. And surely as elected members, they ought to have the right to propose certain measures to the Parliament which involve the spending of monies from the consolidated fund. Constitution says, oh no, they cannot, unless they are authorized by a minister. Now, when it was first realized that such a provision was in our Constitution, there was some debate about it. Back in 1979, when the government delegation went to London to have the final discussions on the Constitution, Clause 44, as it then became Section 44, was one of the clauses which was criticized. But I hasten to say that Clause 44 finds company in practically all the constitutions of the Commonwealth, including all the other Commonwealth Caribbean countries. because it was a policy of the British parliamentary system that only ministers of the Crown could have powers of the kind, could have spending powers. So that in our system, the opposition is free to put forward a bill if they want. The opposition is free to put forward a motion or a resolution if they want. But if it has any financial implications, that is, if it calls for the spending of funds from the consolidated fund, a minister has to support it. Otherwise, it cannot be put on the order paper. And even if it is put on the order paper, the Speaker of the House would have the authority to remove it from the order paper or not to place it before the House for debate or passage. You would have heard me read the words, otherwise than by reduction. Those are very important words. They mean that private members in Parliament can put forward bills or motions calling for the reduction of taxes or calling for a reduction of spending proposals. What they cannot do is to put forward any bill or motion for the increase in any taxes or any charge upon the consolidated fund. And you may wonder, well, how come we haven't been hearing about members of the opposition, who are the bulk of private members, putting forward resolutions for the reduction of charges on this or that, particularly when they have proclaimed their opposition to certain charges? Well, I cannot answer that. In recent years, complaint has been made that the opposition is not getting the opportunity to put forward its resolutions. Now, I follow Parliament reasonably closely, and I have noticed over the years that the opposition has not been making much of an effort to put forward motions on the ground that it is frustrated in that previous attempts to put forward motions have been thwarted by the government. Well, the parliamentary system consists of a number of rules. In many respects, it is like a game of chess. There are moves one can make in opposition and counter moves the government can make, and vice versa. Many of you would know that at the third meeting in any new session of Parliament, private members' business has priority over public business. Every third meeting of a new session of Parliament. And the new session of Parliament is the one that begins when the House meets after it has been prorogued or dissolved. So, an opposition that really wants a resolution to be put before the House and to be debated has to make sure, first of all, that it files the text of the resolution bright and early with the Speaker in the new session and awaits the third sitting when its business has priority. But above all, at that third meeting of the new session, the opposition should not table questions, because if they table questions on the day when their business has priority, the government will take the whole morning and half of the afternoon answering the questions. And there's a catch, because the order on the order paper, which provides for opposition business to be dealt with as priority, is based on a rule of the standing orders that such business must terminate at 5 o'clock. So an opposition that wants to have a motion debated, first of all, make sure it lodges the motion with the clerk of the House at the beginning of every new session, and it leaves it there until the third meeting, and when that third meeting comes around, the opposition has to make sure it does not ask any question, so that it will have time for the House to deal with its motion as a matter of priority, at least until 5 o'clock. But I've noticed over the years that the opposition would file a motion, and the very day when the motion is supposed to have priority, they ask a full quota of questions, and the government plays along, takes their sweet time in answering the questions, and by the time lunch is taken and they get back there, 5 o'clock comes, and then the opposition complain that they are not getting the chance to debate their measure. It is because they are not playing the game as astutely as perhaps they should. The parliamentary system is extremely heavily loaded in favor of the government of the day. No two ways about that. But we saw in the days when Mr. Mitchell was a one-man government, one-man opposition, in the circumstances of a hostile government, he carried on, he soldiered on, he didn't boycott Parliament. He went, did his work, and we heard him on radio at the budget sessions. In those days, the radio did not broadcast ordinary sessions of Parliament, and they do that now. So that the rules of procedure are to be effectively utilized by those who function in the system. Governments over the years make use of them. It's up to the opposition to make use of them in their own way, but they have to be astute about it. assuming they bother to go to Parliament, which is another story entirely, and one for us to take up on another occasion. I would just end this program by recapping the gist of last week's program, the age of majority. I want to thank the very many people who communicated to me and said that they thoroughly enjoyed hearing the presentation and knowing what the law is and has been and how it has been changed. For those who missed the program, in a nutshell, girls were able to give consent for men to have sex with them, or boys, as the case may be, from 1912 to 1966, up to the age of 13 years. And in 1966, the Joshua government raised the age of consent from 13 to 15. So, insofar as the law is concerned, a girl who is not yet 15 cannot give consent. I mean, she can say yes, but the law does not regard that as any consent. And any man who has sexual intercourse with a girl who is not yet 15, whether she says yes or no, is breaking the law and exposing himself to a 5-year imprisonment. And the age of consent has remained at 15 years from 1966 until the hour of now. Nobody has brought it down. Nobody has taken it up. So from 1912 till 66, 13 years. From 1966 till now and continuing 15 years. All right? All right, well, that is all from this program of the law and your program number 828. I look forward to being of further service to you next week, Monday TV, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls. And may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.